I want to just talk about an area of law that my firm handles. And these cases involve inadequate security in commercial establishments, such as apartment complexes, malls, gas stations, and other businesses. One of the most common types of attacks we see involving apartment complexes are sexual assaults. And let me share some statistics with you about sexual assault here in Georgia. According to the 2010 Georgia Family Violence and Sexual Assault Report, 1 in 6 women in the state of Georgia between the ages of 15 and 44 years of age have been forced to have sex against their will at least one time in their lifetime. 45% of these incidents occurred at the victim's home or apartment. And according to the National Sex Offender Registry, in 2010, 25% of the female victims of rape, sexual assault were victimized by a stranger, and 82% of rape victims knew their attacker. Georgia law requires owners of properties and businesses to protect their customers and tenants from unreasonable dangers. These individuals and companies are required to take minimum steps to learn of dangerous conditions and to correct these dangers so their customers or the tenants leasing their apartments are not hurt. But when these businesses do not take reasonable steps to correct the unsafe condition and someone is seriously injured, assaulted, or killed, there is a potential claim for inadequate security. Now let me stress one important point though. Just because someone is injured on someone's property does not mean the property owner or business is at fault. We must prove, 1, that the business had prior knowledge of the hazard or danger, or with the exercise of reasonable care should have discovered it, and 2, the business owner did not take reasonable steps to correct the hazard or prevent the injury from occurring. And it seems that every time you turn on the news, you hear about someone being sexually assaulted in their apartment or in the parking lot of the apartment complex. And these reports are very disturbing. What's more disturbing is that if the apartment complex had exercised reasonable care, a lot of these crimes could have been prevented. When these attacks occur, we typically find one of 2 things have happened. 1, the attacker is a resident at the apartment complex or is a guest of the resident. Or 2, the attacker came onto the apartment complex grounds as a trespasser. Now let me address each of these in more detail. If the attacker actually lived at the apartment complex, it's a challenge for us to show that increased security measures could have kept the attack from happening. This requires a lot of investigative work. Could the apartment complex have screened the tenant better by doing a criminal background check on him? If he came up with a criminal history, could they have rejected him as a tenant? Were there burned out or broken lights in the parking lot or breezeway that were not replaced or repaired that provided the cover of darkness for the attacker? And how long were these lights out, and was the apartment complex on notice? Is the parking lot fenced, or is the fence broken or cut in areas that allow both the entry and the escape for the criminal attacker or attackers? Let's look inside the tenant's apartment. Are the locks on the doors and windows inadequate or broken, allowing easy access for the criminal attackers? Now let's look at when the attacker is a trespasser on the apartment complex property. Our investigation focuses on 2 things in these types of attacks. 1, we need to discover if other attacks, sexual assaults, or other violent crimes have occurred on the property before the attack we're investigating. And 2, we must find evidence to show the apartment complex did not implement the reasonable, necessary safety measures to protect its tenants after these crimes and attacks started to happen. The courts have told us that prior property crimes may give a landlord notice of possible future crimes against a person, and that's the Walker versus Adderhold Properties Incorporated case. Now here are 5 ways we try to prove the defendant business owner was negligent in protecting people on his property. 1, prior crimes. We start by securing the crime reports from the local police department through an open records request. If there are prior violent criminal acts at the apartment complex, previous robberies, shootings, or sexual assaults, then the apartment complex is constructively on notice of a very serious security problem on their premises. 2, the defendant business owner's internal reports. We also look to see if the defendant apartment complex had any internal reports which identified prior crimes in the area. 3, what security practices are in place? Another thing we investigate is what security practices the apartment complex had in place to protect the people that are invited onto its property. 4, prior victims. We may also interview prior victims of similar crimes, and these are especially helpful if the crime occurred at the same location, showing the landlord knew of the prior incidents. And 5, security experts. There are times when we may hire security experts to help us establish that the apartment complex breach the standard of care by not having security when needed or by having an inadequate amount of security. Well, as you can see, the handling of a premises liability inadequate security case can be a challenging effort. You need an attorney experienced in these types of cases. So if you or a family member have been the victim of a sexual assault in an apartment complex or a business establishment, I encourage you to call us right away for a free consultation. It's free, completely confidential. There is no obligation. 770-934-8000.